Hey, what's going on? Have you heard about our radio show? That's right, there's a medical marijuana radio show, and I do it for you every Thursday night at 8:30. In fact, the podcast is available ahead of time every week, and you can get it at 420lawoffice.com. Just click 420 Radio Show, and you can download the podcast, and you can subscribe by clicking a button, and it's going to show up in your phone or in your iPod. So be sure to check out 420 Law Office Radio. I think you'll find it's rockin'. All right, take good care. Hello, this is Stuart Richland from 420 Law Office, and here on the YouTube channel. Thanks for touching base. Today, I'm here to talk about the new memorandum for United States attorneys, the June 29th, 2011 memorandum, which was written by James Cole, Deputy Attorney General, in furtherance of the promise of the Attorney General of the United States, Eric Holder, that we would be getting some further updates on the federal enforcement policy. And indeed, this is a very harsh letter in the sense that it really is intended to clip the wings of some of the out-of-control jurisdictions in particular that have entertained the idea of large-scale grow operations with millions of dollars, that they would still consider such activity as an enforceable activity that they may throw the book at. Federal law still holds that it's a 5-year, $250,000 felony to grow or sell just a little bit of cannabis, and it goes up from there. So what I think is also notable is that some states have made the mistake of going for-profit in this area. And this would certainly fly directly in the face of the Controlled Substances Act. Those states, I think, should take a lesson from California, which utilized nonprofit as a way of correlating, let's say, or justifying the exception that California law makes to allow medical marijuana. By making it nonprofit, California law has justified that it doesn't violate the Controlled Substances Act, at least as far as California judges are concerned. You can read more about that in the case of Normal versus San Diego. But federal law still holds, and a federal judge here in California or in any court will still follow federal law, holding that there is no defense for medical marijuana. Nonetheless, we've seen situations like the case of Virgil Grant, in which the judge followed federal law, but then used state law to decide sentencing. And he actually used state law to decide whether he felt this person was worthy of throwing the book at or not, to see whether he complied with state law was an issue for the federal judge. But that's optional. We don't have a case that says it's mandatory. But most federal judges, I think, would consider the bona fides of a California or state defense to some extent, especially compared with an out-and-out profiteer. So one of the things here in California that distinguishes a legitimate medical marijuana action from an illegitimate one is whether it is truly nonprofit. Some of the states don't have that. And some of the jurisdictions like Oakland, Oaksterdam, we're talking about having multi-million-dollar grows and licensing gigantic grows. Obviously, the federal government won't look too kindly on that. Ironically, here in the city of Los Angeles, the city council and its new ordinance mandate larger collectives shutting down the mom and pops, shutting down the diffuse number of collectives, and requiring a focusing of patients into 100 or 70 specific locations where there will be authorized cultivation. And the problem with that is it flies directly in the face of the federal prohibition against large activity. So if we were to shove all of the Los Angeles city patients into a smaller number of collectives, they will naturally have to have a larger number of plants and a larger amount of money running through them. Isn't it better to simply tax and regulate under state law as we continue to lobby and move forward the concept of medical marijuana as a legitimate exception to federal law with such things as the Barney Frank and Ron Paul legislation that's going through now? So anyway, those are my thoughts. You can see that there is a definite and heavy conflict of law. The conflict keeps getting deeper, and it seems as though the City of Los Angeles ordinance forces additional conflict, not only with reference to concentrating the number of collectives into a smaller number, which will by necessity be larger, but by mandating that each of those collectives, in addition to distributing cannabis, must cultivate on site. That's like saying to a state entity, you must violate federal law twice. You can't just violate the rules on sales, you must also cultivate. I've never heard of a locality mandating a federal crime before. Hopefully, Judge Moore in our case in the City of Los Angeles injunction Part 2 will agree that the city has created an impossibility. As we continue to do our work, stay tuned, and thanks for joining me here at the YouTube channel and on the site. Take good care.